Shot the yellow.
Entrepreneurship, it's our game. The Big Potato Podcast is yours to claim. From startups to scaling up, we cover it all. So don't mess up.
And this is the Big Potato Podcast. Yep. Season 2, episode 8. We are into November, heading towards the end of 2024. Imagine that. Already. What a journey it has been, 2024. So much has happened. So much has happened. We just had elections in the US. World change and impact, I'm sure. And that's something we'll get into maybe in another episode. But we're glad to have you guys, as usual, all the Big Potato Podcast followers and fans out there. Thank you so much for always supporting us, sharing your feedback, constructive feedback as well, helping us to make this show and this platform the place to be each and every Monday night. Yours truly, Kendall, I'm here. My co-host, Stuart, is here as well. Stuart, how you doing, bro?
Hey, good night. Good night to our listeners. I keep saying good night. I always forget it's a podcast. So it's good night, good morning, good afternoon. You know, the time whenever you get to listen to the episode, greetings to you. But I am good. Very excited about this episode. This is something I really wanted to discuss for some time. But, everything happens in its own time, at the right time. So, yeah, I'm here. Excited, as I said. Can't wait to get it going.
Fantastic. And you guys, while you're listening and before we get into the conversation, just head on over and click like, click follow on all our social media pages. I'm talking Instagram, TikTok, Facebook, LinkedIn. Keep up to date with us. Send us an email to thebigpotatopodcast@gmail.com. Send us an email. Give us your thoughts. Give us your feedback. I mean, this is season 2, episode 8. We had 12 episodes in the first season, so it means we have done 20 episodes now. Imagine that.
20 episodes. That's a big number.
That is a big number. I'm telling you. All right. So we really thank you for your support, that you continue to encourage us and drive us forward. So leave us a comment, leave us a line. Let us know if there's anything that you would like to discuss or you would like more of on the podcast. Hey, we're here to support entrepreneurship. And as Stuart said, the conversation tonight is another one of those special editions. So we're not talking to an entrepreneur per se tonight, but we're talking to someone who can help entrepreneurs to understand the building blocks, important and key building blocks in their business that sometimes is overlooked until it's too late. So let me take the opportunity tonight to introduce our guest. He is technical examiner at the Trinidad and Tobago Intellectual Property Office. That's right, guys. You got it. We're talking intellectual property tonight. He examines patents, industrial design, new plant variety, and integrated circuit applications. He's also heavily involved in the education initiatives of the TTIPO and is a certified trainer under the National Intellectual Property Training Center. Yep. As usual, we bring the experts. He holds a BSc in Geography and the Environment, as well as a Master's in Intellectual Property. Without further ado, let me introduce Mr. Nicholas Gayahpersad to the Big Potato Podcast.
Wow, what an introduction. Thank you so much for that. And hello and good evening, good morning, good night to each and everyone who is taking in the Big Potato Podcast.
Nicholas, how are you, man?
I am good. I am great. I am alive. All is well. How are you?
I'm great. We're doing good on this end. And as I said in the intro, we've spoken to so many entrepreneurs, Stuart, so many industries, so many business leaders. And one commonality in everyone and their business is I guess I was about to say the right to rights.
Mm-hmm. Yes, correct.
So tonight it's important. It's a key discussion here tonight. So I'm looking forward to it, and we're going to get into some key topics on the intellectual property tonight.
Well, in fact, if we go all the way back to season 1, episode 1, what we discussed, what is an entrepreneur?
Mm-hmm.
And that is the focus of this podcast, entrepreneurship. And people tend to conflate the two. But the difference is that the entrepreneur deals with innovation, whether it's a new process, a new product. And these things have fruits, which are called intellectual property.
Mm-hmm.
So we're really trying to have an entrepreneurial conversation where the young entrepreneurs will understand there are other revenue streams that could blossom from your idea. So we're going to discuss how you protect it and those sort of things. But again, I said, I'm very excited about this episode. Very, very excited. I know it's going to be very informative.
For sure, as usual, insightful and exciting discussion. So before we go any further, let's jump into our first segment tonight. It's called, you know it by now, What Caught Our Eye? Key, quick entrepreneurial insights on articles, stories, or any newsworthy events that may have caught our eye over the past few days. I'll kick it off this week. I actually came across an article, not recently, a few weeks ago, or a couple of months, I should say, and I saved it because I said, we as sports lovers, Stuart, this is going to come back up.
Yes.
And the article is actually entitled, Pro Sports has a piracy problem. Pro Sports has a piracy problem. All right. It actually was in the Harvard Business Review. Now, I'm going to keep it quite short. Basically, the article outlined that the piracy of live sports across the board, but this one tended to focus on the NFL and some American US sports, is impacting the industry with about 17 million viewers using illegal streams to view the last Super Bowl. 17 million viewers. And I guess that's all that they could have recorded, right? So I'm sure it was more. Basically, for the NFL, if you don't know what that is, the National Football League in the United States of America, they are saying that 35% of the NFL's fans actually pirate content all the time. So let me break that down for you. That means you're going on the internet, you're going onto your streaming platform, your pirate streaming platform, and you're streaming this event. Because it's not only limited to sports, it's across the board, movies, songs, music, you name it. Now, the NFL, the NBA, and UFC alone came together because they're trying to combat this. And they actually summed it up that they are losing, according to them, the opportunity to make $28 billion in potential annual revenue due to piracy. Interesting, right?
Mm-hmm.
Now, this is no small fee. And as I said, I am a sports lover. Stuart is also a sports lover. We always looking for the opportunity to see our teams play and to see live action. So that is why this caught my eye, really. Now, one of the ways that they tried to combat this was by doing coordinated site blocking. That should be coordinated site blocking, where basically block multiple piracy sites at once. So in other words, they try to drive users to a more legal option. I wonder how that has worked. with the number of piracy sites that are out there. Of course, addressing piracy effectively can help reclaim some of the money. Remember that 28 billion that they say they're losing annually? But how much of that could really be recovered and reclaimed with the number of piracy sites out there? So is blocking really a deterrent? And of course, they're talking about making legal streaming more accessible. But most of the legal streams have a cost attached to it. And as small as that cost may be, are we as viewers and consumers already so, I would like to say, entwined in watching sports for free that we refuse to pay? So I brought this to the forefront tonight for the intellectual property discussion because it's something that happens all the time. Even right here in Trinidad and Tobago, the people use illegal means of consuming content. Nicholas, could you shed any light on stuff like this in terms of the illegal streaming and so on?
Well, I'm very, very happy that you brought up this topic because we recently concluded a regional conference on anti-illicit trade. And in that conference, we discussed not only the movement of pirate and counterfeit goods, but we also spoke about illegal broadcasts or pirated broadcasts and that. And you raised some figures just now, right? Which is very important. It's a very important note. So how I want to actually address this situation is I want to address it on two fronts. Actually, let me say on three fronts, right? We're going to use three different parties here to address this issue. So the first issue is that when a stream is illegally broadcasted, what you are doing is you are not only infringing on the intellectual property rights of the broadcasting station. So let's just say IBOMAQ or something, right? You are taking away revenue from them. And I know a lot of persons would say, well, it's a big broadcasting network. If I go ahead and I pirate or I illegally share this stream to my brethren, it ain't gonna hurt them in any way. But the thing is, if thousands upon thousands of persons are doing the exact same thing, it adds up. Right? So you are taking away the revenue from the broadcaster. The next thing you are doing now is you are also taking away revenue from the teams and the leagues, because the teams and the leagues that are playing, they also depend on the money that broadcasters would pay to them in order to broadcast their games. It's not that the teams pay the station for the broadcast. It is the opposite. The broadcasting station is getting the rights to broadcast the game. And in order to do that, they have to obtain permission from multiple parties, including the teams and the leagues. So when you illegally share a stream, or you illegally stream, or you stream from an illegal website, or illegal a website that do not have the rights, I should say, in order to bring this stream to you, you are taking away that revenue from them.
Right.
Now, what does that do? If there's a loss of revenue because they realize, well, persons are accessing this content for free instead of actually paying, it is a deterrent. Because at the end of the day, intellectual property, just like entrepreneurship, is all dollars and cents. If my effort is not producing a specific outcome, is not producing a specific economic benefit, then I might have to cut my losses, right? So this now takes away the opportunity for persons like us who can't afford to buy a plane ticket to go to the US to watch the Super Bowl, right? It takes away that ability. It takes away the ability to bring that stream here into Trinidad and Tobago, which would probably be the cost of, okay, let me just say the cost of a stream is a pay-per-view is what, 50 US? Somewhere around there. Right? If you compare that to the cost, to what it will actually cost you to go to the States and watch a game, it's a minimal fee.
True.
Right? If you had to compare them.
Mm-hmm.
The next thing now, the third party involved in all of this is yourself, the person who streaming. Now, a lot of these websites and, a lot of persons would have had this experience is when they go to find, they probably go on Google and they probably type in Super Bowl live stream free or something like that, right? And you'll probably get like 10 websites offering free streams and all these kind of things. And from the minute you click on one of them, you get like 10 pop-ups, right? These things actually are riddled with hackers, spam. So you are now at the cost of, in your mind, $0 to get this free stream. You are putting your devices at risk. You could get if you have your credit card information stored on your laptop, they could get access to your credit card information. If your laptop is not properly secured, you could pick up viruses, and then that $50 you didn't want to pay for a pay-per-view will still cost you hundreds to thousands of dollars to fix your devices if they get infected. And also, if, God forbid, you have to go on and redo credit card and claim for fraud and all that kind of thing, you have to go through all that process. So at the end of the day, is it actually worth, when you break it down in that way, is it worth it to participate in or to look at a sporting event on an illegal website? Or is it worth it to put the 50 US in to get the stream? So that's kind of my point of view on the whole situation.
Fantastic. Excellent points as well. I mean, some things that probably our audience may not have been thinking about. Stuart, is it worth it?
Well, definitely some great points raised. I would just play the devil's advocate though. My question is, we discussed it in the last episode, the culture code. I mean, ever since I was young, the Betamax and the VHS, as you press play, you see FBI warning.
Mm-hmm.
Do not copyright. Do not copy this tape. But everybody in the neighborhood has their copy, right? So again, going back to the culture code of our region, I understand in America, with North America, not just America, Canada as well, Europe as well, they will have different cultures and they will place more importance on certain things. But I'm not too sure for our region specifically, to be honest, how much we value IP on a whole, how much we willing to pay for that. I mean, when Nicholas mentioned just now, they're removing funds, revenue streams for some of these leagues. And so, again, for the average man in the Caribbean, Mbappe making how much? £100,000 per week? So again, that's the devil's advocate. I'm not too sure, again, as I said just now, how ready we are as a region, and I'm just speaking for our region here, to really appreciate the importance of intellectual property and valuing what these other people created and not just using it for your own benefit. Yes, there are many risks, as we mentioned, in malware and all of these things. But another thing to consider is that, is this really a problem that they should devote too much resources to? Again, I'm playing devil's advocate. So for instance, you squash one site, they change the URL extension from .au to .to, and it's up again next week. And you spend more resources, your legal team being paid, going around smashing all these sites, and more just popping up, It's, to me, it's a very challenging issue. And I think it might all stem from a lack of education, specifically, again, for our region where we're talking about, in terms of the importance of the intellectual property.
Well, to that point, what I would actually like to say is that this is on the topic of enforcement, right?
Mm-hmm.
So the persons who are being affected economically, their pockets are being affected. So the leagues, the broadcasters, and them who, essentially we are taking money from by doing a free stream, right? If we were to engage in that, they would have to decide whether it's worth it for them to seek legal action in Trinidad and Tobago. Is the harm from Trinidad and Tobago actually denting their pockets in any way, right? So that's
How much
one thing
damage
they will
is?
consider. They might say, yeah, it's not really doing anything. But then, again, it comes back to the risk that you are putting out there on yourself.
Mm-hmm.
Putting your information out there, because usually, they have a saying, not some things look like it's free, but it's not really free.
Mm-hmm.
Yeah, there's a price to pay. So, are you still willing to risk your devices getting damaged? Another thing is that when persons obtain or find access to a free stream, usually it's a poor quality. It's not the best. So you might be watching a football game and the ball looking pixelated. Some people might want to see every single blade of grass and every bead of sweat rolling down the player's face, right?
Mm-hmm.
Right.
So, and then on top of all that, you might get ads you don't want to see popping up, right? Especially let me just say you're watching with a young one, and certain ads pop up that you don't want them to be seeing, right? So there's a lot of different aspects to the personal harm, I would say, that comes from watching these streams. And then of course there's the enforcement arm, where does it make sense for them to do it? So I mean, it's not a perfect world, and you wouldn't be able to change everybody's minds, right? But at the end of the day, it all boils down to dollars and cents. At the end of the day, are they still making enough? Is the infringement in Trinidad and Tobago worth it? And of course, on a personal level, is it worth it for me to pay for a stream or to watch it on a illegal website?
Mm-hmm. Well, let me jump on one of the points you raised there. I wouldn't mention the provider, but sometimes you will pay for your cable package, sit down to watch the greatest football team in the world. Which team is that, Kendall?
Barcelona.
No, sorry, Real Madrid. Right? So, you sit down, get prepared, and all of a sudden, it's either the game not available in the region, they're showing a wrong game, or the game itself is so pixelated, as I mentioned, in terms of the quality of the broadcast you're getting. It's freezing. Now, you paying your monthly, you're moving legal. You're paying your monthly bill for the cable, and you're still not getting what you're paying for. You're not getting that value, that experience you expected. And then now with the mentality of the viewers and the consumers, where, we get so spoiled. You want to see what you want to see when you want to see it. You don't want to be limited by what they're showing on local programming or on cable programming. On demand. So, as you said yourself, is a very challenging issue. It's a very difficult reality we're dealing in.
And let me just wrap up this what quarter I here, because we could go on and on when it comes to streaming.
Sure.
For sure, because as I said, we haven't even dealt with music and movies and all these other things, which will come up later. But you raised a good point there. And sometimes I wonder to myself if some of these broadcasters are also illegally streaming themselves. And I would just leave it there.
Stop there.
So Stuart, what caught your eye this week?
Yeah, let's switch that topic one time. Okay, so what caught my eye was an article from Reuters. It's by Blake Britton and came out yesterday, actually, November 11th. The name of the article is KFC Sues Churches Over Original Recipe fried chicken ads.
Hmm.
You hear that, Kendall?
Mm-hmm.
So KFC has taken Church's chicken to court because in their recent ads for chicken legs and thighs, Church's said we are going back to our original recipe. And KFC basically saying they're infringing on their trademarks because they've been advertising original recipe since 1972.
Mm-hmm.
But my question is, can you trademark original recipe?
I wanted to know the same thing.
It's very confusing. So, as I said, I was doing some research for the episode and I was like, okay, we're going to have a IP expert on tonight. I think this would be a good question to pose to him. You know, what are your thoughts on this? Are there any merits to this case? Can you stop someone? So, like, let's take it local. Can Japs or Royal Castle not advertise, we have our original recipe?
Well, actually, okay. I will step away from the local examples and I will stick to the KFC and the Church's chicken one, right?
Right.
A lot of attorneys would tell you, or they also like to use two words together a lot, and those two words are "it depends."
Mm-hmm.
Right? So, how trademarking would work? A trademark is an exclusive right for a sign that is used to distinguish the goods and services of one trader from another trader. Right? KFC, if they were indeed, and I mean, I'm not overly familiar with everything KFC has done, but if original recipe was something that they used frequently in the past, and if consumers, when they hear original recipe, they automatically think of things like KFC and stuff like that, then KFC may have a case. Because what if now, when Church's advertise original recipe, people think they have something similar to what KFC have?
Mm-hmm.
It's all about the consumer at the end of the day.
That was the claim, that they would be confusing the consumer.
Mm-hmm. So that could be a point that they are tackling things from. A counterpoint could possibly be Church's to say that, you know, they never actually officially protected the term original recipe.
Mm-hmm.
And when it comes to protecting or obtaining trademark protection, there are specific rules in place that examiners would put it, would I would say enforce then in order for something to be granted.
Mm-hmm.
So that would be another thing to figure out if it was legally protected. But then there's another little thing, and this is like going into the rabbit hole of trademarks now, where there's something called famous or well-known marks then.
Mm-hmm.
Right.
And in this case, KFC original recipe might be considered a well-known mark. We are not sure. It is all going to depend on how well KFC could argue that. If they could indeed argue that the average consumer, when they hear original recipe, they automatically think of KFC, they might have a case. So, like I said, it's an it depends situation, but definitely this will be a case to take a look at and to follow, because I suspect there's going to be a good fight on both sides.
Right, right.
Mm-hmm. I mean, I have also seen like other fast food restaurants in the fried chicken arena use terms like spicy and these things. Now, from an entrepreneurial point of view, even in terms of naming your business, sometimes they say that you can't, and you could correct me on this, Stuart, you can't use certain words to name your business.
Correct.
Right? No, and I'm glad you brought up the point about the famous marks. Because if the mark is famous enough, am I allowed to use it even if it is not legally protected. So if I decide to start as an entrepreneur, because it's entrepreneurs we're talking to here, start my fried chicken business tomorrow, and I'm setting up business and I'm saying, boy, they feel that they have XYZ. Let me show them how to really bring this recipe to life. This is the real spicy chicken here.
Mm-hmm.
Can I do that?
When it comes to, well, and I would have mentioned rules to trademark protection. So you would not obtain trademark protection over descriptive words and over generic words. Words that would be commonly used in a particular class of goods then. So we're talking about food, right?
Yes.
So descriptive words like spicy, hot, tasty, flavorful, delicious, all of these things that more or less gives the consumer a general idea as to what they're buying into right off the bat.
Right.
Those are things that would not be granted trademark protection. Does not mean that they can't put it on the label. It doesn't mean you could have, and I'm going to use a bad example, right? It doesn't mean you can't have Nick's hot, tasty, delicious pepper sauce. Hot, tasty, delicious pepper sauce is not going to get trademark protection. Nick's, on the other hand, might be.
Okay.
On top of all that now, if I had a unique, let me just say I had a symbol or a logo attached to all of that, the rules apply to the logo as well. I can't have an image of a pepper.
Okay.
Because that is also telling persons what I'm selling. I mean, if the pepper is drawn in a very abstract, unique way, so it might seem like a pepper, but it's not really a pepper, there may be a case there. But common words like that would not obtain trademark protection. So that might be another angle churches might want to argue with. Original and recipe, right? It might be a counterpoint on them. Like I said, looking at this case is going to be very, very interesting because there might be some precedent being set in this case.
Yeah.
In terms of how persons treat with well-known marks. But to come back to another point that you were making, certain well-known marks, even though they are not protected in some countries, because they are distinctive enough and the average consumer would know of these marks, would have protection whether they are legally trademarked or not. So let me just say, for example, in a world where Nike does not have trademark protection in some random country, right? But somebody in that country selling Nike shoes or using a brand that says Nike in it, or using the actual brand itself, there might be a case there because Nike is a well-known mark. Also, persons would not be able, let me just say Nike is not protecting their mark in a specific country. Let's call it country X. Persons would not be able to apply for the Nike registration in that country because of the concept of well-known marks. So, again, it all comes, there's a very much an it depends situation, and there's also the aspect of proof and factor in a little bit of well-known marks inside it. All that is to put it back into food terms, the recipe then for how this thing would work.
Right.
I'm telling you, I mean, we already having a flavorful discussion.
Off the bat.
And this What Caught Our Eye segment is brought to you by IBOMAQ, which is trademark.
Not yet.
Not yet. Whether you're seeking guidance or solutions for your business, we're here to help. Contact us via IBOMAQ868@gmail.com. That's IBOMAQ868@gmail.com, and let's discuss how we can collaborate for your success. And we're back on the Big Potato Podcast. our special guest tonight, Nicholas Gayahpersad. And we're talking intellectual property. Now, Stuart, I know you're ready and you're revving and you're raring to go.
Yeah, of course.
Let me just get Nicholas to get some key definitions, as he said, out of the way early. For the purpose of our audience, we know not everybody would be familiar with what exactly intellectual property is and intellectual property rights. So, Nicholas, if you could probably sum that up for us briefly, just for the purpose of our general audience, and then we'll get a little bit deeper and more specific into it.
Absolutely no problem. This is part of my job after all. So intellectual property. Well, first, let me start with the Intellectual Property Office. First of all, for those of you listening, there is an Intellectual Property Office in Trinidad and Tobago. Not a lot of persons know that. Because from the minute someone asks me, well, what do you do for a living? And I say, well, I'm a technical examiner. I examine patents. The first expression I get is, that exists in Trinidad and Tobago? And I'll be like, yes, the Intellectual Property Office has been in existence since 1998. And two of the main responsibilities of the Intellectual Property Office is to grant intellectual property rights in the area of industrial property, and then, of course, to educate persons on intellectual property and, of course, intellectual property rights. So when I do a class, or I do a lecture, or I do a presentation to any user group, I always like to start by saying intellectual property exists everywhere. It is all around you. It is in everything in front of you, around you, under you, you name it. It is in your cell phones. It is in the chair that you're sitting in. It is in the roof above your head, your lights, everything. Intellectual property exists all around you. And the basic definition for intellectual property is, it is the expressed creations of the human mind. So you have an idea for something, and then you take that idea and you bring that idea into reality. So it's not just a thought in your mind anymore. It is something that is physically expressed. It is now a tangible thing that everyone can see and interact with. That is what we call intellectual property. So if you take a look at the two words as well, intellectual and property. Intellectual, it comes from your mind. Property, it is a physical thing. Right. So that is the basic definition that we would go with when we teach persons about intellectual property.
Now, I know under intellectual property, you have things such as copyright, trademarks, patents. Could you give us a brief description or overview of those?
Absolutely. So under intellectual property, you have two main categories. You have industrial property, and then you have copyright and neighboring rights. Under industrial property, you have different types of intellectual property rights. You have patents, trademarks, industrial designs, integrated circuits, new plant varieties, and geographical indications. Those are 6 different types of intellectual property rights. And then, as I mentioned, you have copyright and neighboring rights. What these rights do is they protect different things. So not one intellectual property right is going to protect everything that we could come up with. For example, I consider myself to be a little bit of a musician. So let's just say, I write a song. The intellectual property right that is going to protect that song is copyright. But then I might have a friend who is an engineer, a mechanical engineer, and they figured out a unique hinge or a unique mechanism that is going to make doors swing in a more efficient or different manner. That could be something that we would consider an invention. An invention is protected by a patent. So we see 2 different types of expressions. Both are intellectual property. However, there are different intellectual property rights working for both things. The next thing I would like to say is that you are not limited to one intellectual property right per product. In a lot of products that we have these days, you have multiple intellectual property rights protecting various aspects of these products. So let me use the example of Gatorade. For those of you who don't know, the formula for Gatorade was something that was patent protected because the formula was solving a problem. The problem being the introduction of electrolytes into athletes to allow them to have more endurance when on the field.
Right.
This was solving, the formula for Gatorade was solving that problem in a technical way. So the formula for Gatorade was patent protected. The bottle, the original Gatorade bottle, or any of the Gatorade bottles now, I should say, the design of the bottle can be protected by something called an industrial design right. And then, of course, the branding for Gatorade is something that will be protected through a trademark. So in one product, you could see so far a minimum of 3 different intellectual property rights working to protect various aspects of the product.
Can you tell us about related and neighboring rights, and specifically in the music industry?
Okay, so to answer that question, I actually want to holistically address copyright and well, we say neighboring rights in Trinidad, but some territories would say related rights. So copyright, the definition of copyright would be the protection for original literary dramatic music works. Original, right? So this applies to things like your photography and your movies and your poems and your books and of course your songs, your music. Neighboring/related rights. This is the protection for broadcasters, as we were talking about earlier. This is also the protection for producers of music and also the protection of performers. So persons who are, well, let me use a song for example. So let's take for example, I want to take for example Ed Sheeran, right? Ed Sheeran is a very famous songwriter, wrote thousands of songs. However, Ed Sheeran does not always perform these songs. Sometimes these songs may be sent to other artists to perform. So, for example, so in one song, you might have someone writing who would enjoy copyright because they are writing the song. You might have the musician who is scoring the song, so that they will also enjoy copyright because the musical score is something that is written. It's a literary device. Then you have the performer who would enjoy performance rights or the related/neighboring rights. Then you would have the producer who records the song and puts it into an MP3 or into a digital format. And then you have the broadcasting organizations who would then take the song in this case and communicate it to everyone else or distribute it to everyone else or broadcast it over the airwaves and stuff like that. So that's kind of how the pie is sliced up in a very, very broad sense when it comes to one piece of music. Now, when it comes to things like, and now we're going into the broadcasting aspect of things now. When you go into the broadcasting aspect of things, especially when it comes to music, we are talking about things like streaming and of course airplay, play on the radio and all these things, right? This all falls under something called communication and distribution. So the music is moving from one spot and being disseminated to multiple persons, right? Multiple devices. Usually, it takes the form of a streaming platform or a radio station, or it could even be things like websites like YouTube and all these kinds of things. When a stream takes place or a song is played, usually it means that royalties go back to the rights holder. So every time a song plays on the radio, monies go back to the rights holder. the copyright holder. Now, it might be difficult for someone to monitor the amount of times a song is being played on the radio, and let's just say it's being played on multiple stations. It might be difficult to monitor how much time somebody on YouTube click on the song. It might be difficult to monitor how much time someone streams it on Spotify. So in the situation where it's being played on the radio or being played for, let me just say, a party or something, a concert or something like that, you have organizations such as collective management organizations who would monitor airplay on the behalf of the copyright owner, as long as the copyright owner has that agreement in place with the copyright management organization, with the collective management organization. So they basically do the work on behalf of the copyright owner then, in order to make sure royalties are calculated and then reverted back to the copyright owner. So that's kind of how that works. Now, copyright collective management organizations is something separate from the IPO.
Right.
So that's why I say I can't really speak about the formation or how they would operate or their practices and stuff like that. I could only kind of just educate you on what one of their main or their priority role is supposed to be.
Right.
But we'll cut.
And then you also need to remember there are also mechanical rights and synchronization rights for music as well. You know, when you put your song in a video game or in a movie, you're entitled to synchronization rights. And if you place your song like on a CD, a physical CD, you have a mechanical rights collector as well. So there's a lot of different ins and outs that many people don't understand and have no awareness of. So that's why, as one of the reasons we thought this episode would be so important. But based on what you just said as well, I have two questions there. I don't know which one to go with.
But before I ask the questions, I would like to say that copyright and how, especially when it comes to music, this is a session that we would usually spend a couple hours on, because it gets so intricate and so complex so quickly. It takes time to navigate through everything. So just to kind of, this might actually be something for, I'm not sure if you want to go deeper into copyright in a future episode, but that might be an idea for a future episode.
A whole episode by itself. Because I used to be in the entertainment industry, and we had our dealings with the collective management organizations, and so in fact more than one. We dealt with COT and we dealt with another one I won't mention, but I have some experience in it, so we could really do a whole episode on that. But let me ask you about regional licensing and sovereign rights, because some people will think I copyright my story in Trinidad, so that means it's protected globally. You know, could you explain to the audience how that really works?
Well, okay, so when it comes to copyright, now, copyright is a non-registrable right, so you don't actually come to the intellectual property office and fill out a form and get a certificate at the end of the day stating that you own this piece of music, right? It's an automatic thing. When you publish something, and we're going to use a book in this case now, you publish, actually, no, let's go back to the music. You publish on an online platform. Who has access to the online platform? Anybody with an internet connection, most times, unless they're region locked, right?
Right.
Now, copyright, or your rights under copyright, would more or less extend to the countries that fall within specific international copyright treaties. So Trinidad and Tobago belongs to a couple. We have the Rome, we have the Rome Convention, the Berne Convention, all these kinds of things, right? We also have our Copyright Act as well. So these would stipulate. We also are a part of TRIPS, which is under the World Trade Organization. All of these things would stipulate, or more or less have at the base level, harmonize laws in terms of copyright. So let me just say I produce a song in Trinidad and Tobago, I release a song in Trinidad and Tobago. Somebody in the US could listen to my song, yes. There would be an overlap in terms of how the laws would operate in Trinidad and in the US, with very small differences. In most cases, the difference is the length of time in which the song will be protected for.
Mm-hmm.
So when you upload music to a online platform, yes, anyone with an internet connection will have access to it. The thing is, when it comes to infringement and enforcement, again, that is all going to come down to how the law is worded, how the law is stated, and how much years of protection they would have on that. And again, usually it's, in most cases, it's the life of the author, plus in Trinidad and Tobago, it's plus 50 years after death. In the US, I believe it was 75 at a point in time. I'm not sure if they changed it. And in Jamaica, I believe it was 90. I'm not sure if they changed that.
Mm-hmm.
So that's kind of how it would operate in a nutshell. Again, this is also something that you could spend a good hour talking about.
Tons of time.
Yeah, tons of time could go into this. But the base thing is that, okay, let's just say someone uploaded a digital copy of their book to Amazon Books then, right?
Mm-hmm.
Again, persons would have access to that. Persons would be able to purchase a copy of the book, a digital copy of the book, to download it on their Kindles and all these kinds of things. If someone is ordering a physical copy of the book, they are buying a physical copy of the book. The money goes back to the person who is in charge of the account that is uploading or that is putting the book up for sale. So at the end of the day, most creative persons, or the persons who are operating in the copyright industry, they want to ensure that when they put out a product, and bringing everything back into the entrepreneurship world now, when you put out a product, you want that royalty coming back to you, you want that money coming back to you, you want that profit coming back to you. That is one of the main goals at the end of the day. Of course, you want recognition as well. But first and foremost, you want to make sure you get paid for your work.
For sure.
One of the issues that comes into play when it comes to cross-border infringement, let me just say somebody decide to copy the book and copy the song, or illegally sample the song in another country. Well, and at that point, it is up to the copyright owner now to enforce on that. What strategy are they going to put in place in order to stop the infringement from taking place, or stop the illegal photocopying from taking place if it's a book in this case? So, like I said, there are many different ways we could sway this conversation. But at the base level, the right that works is copyright. If you are uploading to a digital platform, usually these digital platforms would have specific rules in place when it comes to the purchasing of a product, when it comes to accessing content, and copyright. Well, in most cases, there's a little bit of harmony in terms of how copyright rules would work on a worldwide scale.
And
With
that's
subtle
using
differences.
And that's using the example of copyright. But if we were to use the example of like trademarks, you know, every now and then you open a newspaper, you see a list of logos and brands that want to be registered to operate in Trinidad. So in terms of that regional thing, it's not as though, you know, your trademark is global. As I said with the example of KFC, you know, there's some brands, some familiar marks that, you know, you'll associate with the brand, but still, I think the entrepreneur should understand that depending on the markets you want to operate in,
You
may want to
register it
in those specific markets and get the sovereign rights for those markets as well.
Yeah, so when it comes to the industrial property now, there's a different strategy. So industrial property rights are territorial, right? They are granted by the governing state for that specific state. So only Trinidad and Tobago could give you rights in Trinidad and Tobago. We cannot give you rights in the US. That's up for the US to do. Now, there are regional systems. Sadly, the Caribbean doesn't have one. But for example, the European Union has a regional system where they would have harmonized specific rules and laws in terms of getting certain things registered. There are also international filing treaties that would allow someone who wants to apply for patent protection, trademark protection, industrial design protection, in order to have their application be submitted to multiple intellectual property offices worldwide simultaneously. So it's an easier way of tracking. It's an easier way of managing your filing in different countries. Now, as an entrepreneur, you want to ensure that you are protecting where your market is.
Right.
And usually this takes the form of market research and foresight. Plenty times we would have entrepreneurs and creatives come to the office and they will ask us, well, you think this product could do good here and you think this product will do well here? And I will have to tell them, well, I can't say that, because you have to conduct your own research.
Correct.
How much money is it going to take for you to come up with this product? How much money is it going to take for you to enter this market? Is this a market I should be entering in? Let me just say, for example, I wake up tomorrow morning and I am inspired to design a brand new style of snowshoes. I'm not going to protect snowshoes in Trinidad and Tobago because we don't have snow here. I would protect that in a country where they have snow.
Yeah.
So you figure out, you determine where your market is going to be. And then you start looking at filing for your intellectual property rights. Again, it's a strategy. It's a lot of foresight. It's a lot of planning. It's a lot of research that goes into it. But once it is done correctly, and of course, you as an entrepreneur add your passion and your drive into everything, you could see some success. I'm not going to guarantee it, but obviously, because things could change, but you could set yourself up for success.
No, Nicholas, I'm glad that you mentioned that. And a couple of things that you mentioned there, I just want to touch on briefly before we take the next break. One is export of goods. And I think on the last episode, our guest, Tamika, right? So she manufactures tea in Grenada and actually has a vibrant market outside of the Caribbean, so in the US and so on. So let's just use the US as an example. Based on what you're saying, it means then that she would have to protect her brand in the US as well. I just want to hit home that point for our entrepreneurs locked on. Is that so?
Correct. That is correct.
Right. So, for example, this brings me to the next part of what you just mentioned, or what we have spoken about on the podcast before. Entrepreneurship, as we know, Stuart, is on the rise, and it is thriving in this region in particular, the Latin American and Caribbean region. We've checked the stats and it's well ventilated how many entrepreneurs are coming out of this region, and it's buzzing. Entrepreneurs in terms of intellectual property, we just use a general term. Most times, you're not going to want to, you're going to start here, but most of the entrepreneurs we've spoken to over the numerous episodes, they end up building their brands outside as well and exporting, expanding, growing. What are some of the basic steps that entrepreneurs from Trinidad and Tobago and our region should look at as they start to grow?
Okay. Well, we touched a little bit on it a couple of minutes ago. So identify the markets that you want to operate in. And I'm going to talk about the business aspect before we go into the IP aspect. So identify your markets. Identify the amount of competitors you have in those markets. Well, basically do your SWOT analysis is what I'm trying to say. Right? What are the opportunities? What are the threats? What are the weaknesses? What are the strengths? If you are trying to enter into markets where you have to do translations, for example, non-English markets, make sure that what the product that you're trying to sell, make sure the branding that you're going with does not translate into something unfavorable in these markets. This is a very real situation. There are a lot of brands that would go into foreign markets and just would not do well because of what the name translates into. And one of my seniors, my boss, Mr. Aching, he likes to use the example of the vehicle brand Tata,
Right.
which is a very, very it's a multi-million-dollar brand in India. But when it came to Trinidad and Tobago, not a lot of persons wanted to drive a Tata van because of what we know Tata to mean.
Correct.
So take into consideration what your brand is going to translate to. Also, again, your competitors and all these kinds of things. The next thing is, if you are thinking about manufacturing in a different country and maybe selling in a different country now, you should, of course, apply for your intellectual property rights in those countries, because what do the intellectual property rights do? The intellectual property rights give you exclusive rights. And these exclusive rights are the exclusive right to prevent, and we call intellectual property rights negative rights. It gives you the right to prevent the making, selling, distribution, and the licensing of your product, of your intellectual property, without your permission. You have to be the one, or you will be the one in charge of granting a license or granting permission to do any of these activities. Also importation as well. So if you have a design, or you have an invention that you want to get patented in a different country, make the application first before you go ahead and start producing and start engaging in manufacturers. Because if they, for some reason, decide they want to run away with your invention, then you don't have a legal right to stand on. Legal rights, at the end of the day, provide you with proof. It says that you are the owner of this particular invention. I could go around and tell everybody that I am the owner I was the original creator behind the family computer, or the original Apple computer. But how do I go about proving that if I don't have a certificate behind my name saying that I was the one who created this thing? Then I just talking for talk.
Right.
So at the end of the day, you want to be able to have that legal right to stand on it. It increases your chances when it comes to enforcement and in terms of battling infringement. And one more thing I will add is consider two things. Consider whether it is feasible for you to manufacture, or consider if it is feasible for you to license to another company to manufacture. Is your item a standalone product, or is your item a part of a bigger product that they need your ingenuity, your innovation in order to operate? So that would just be some of the considerations I think would be beneficial.
Thank you so much, Nicholas. I mean, so many bombs dropping tonight. It's just like boom, 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 and we're not stopping at all. But we are taking a short break, and we'll be right back on the Big Potato Podcast. From Ibadan to Helyard, from slavery to independence, learn how Helyard, the Trinidad All-Stars, created the Trini identity and how that was leveraged for our independence. Get your copy on Amazon now. And that's right, guys. We are back. We're talking intellectual property tonight. Oh my goodness, we're hearing about trademarks, industrial rights, is it? No, not industrial rights.
Industrial property.
Industrial property. We're hearing about geotag, is it? Geographic indicators. And I wanted to talk about that later. Later. But so much copyright and so many different things. I hope you guys are not getting overwhelmed out there, because we're just shedding light on Plato's Cave still.
Ah boy, Plato's Cave. Ah boy.
And on that note, Stuart, I know you have the next question already lined up.
Well, my question, according to a famous show called Shark Tank,
Mm-hmm.
do you own the patent? Do you own the patent? They love to ask the presenters, the applicants, that question. Because that's one of the reasons we're having this conversation as well. By having ownership of these intellectual property, you now have the right and the ability to attract investors. Because what investor want to invest in you and you don't even have ownership over your product or over your process? So again, do you own the patent, right? It's an important question. Now, moving on, I'd like to ask Nicholas, in Trinidad currently, which industries do you see the most IP being generated? And which ones do you see the most opportunity for growth for entrepreneurs to move into?
Oh gosh.
That's a question you can answer.
That's a diverse question. Because I could talk about it from the different intellectual property rights. So at the office, I would say the intellectual property applications we receive, there are three main types of applications we would receive, I should say. We have patents, we have trademarks, and we have industrial designs. Of course, each one protects different things. So a patent is the IP right that would protect an invention. A trademark, as I would have said earlier, is the IP right that protects signs, your brands and stuff like that. And then you have industrial design rights that protects the ornamental aspect of something, or the way something is designed, the 3-dimensional and the 2-dimensional aspects of something. Now, when it comes to patents, now, as I would have also said in the previous segment, you try to get protection where your market is, right? What does Trinidad primarily boast about in terms of business? Oil and gas, right? It's something that we go back to. I mean, for want of a better term, is the well we go back to, right? So you would find a lot of foreign applicants filing for patent rights over oil and gas technologies in Trinidad and Tobago. So we see a number of oil and gas technologies being protected here. Also, next to that, Trinidad and Tobago, or at least I would say in the Caribbean, we suffer from a lot of lifestyle diseases. So diabetes, high blood pressure, arthritis, all of these things. So a lot of our patent applications, again, come from foreign applicants, and they are for medications that address and treat with these things. So that is if I were to look at the industry, those are the main things that we receive from patent applications and 99% of our applications are from international applicants or foreign applicants.
Interesting.
Now, when it comes to trademarks, that number is a little bit different. I would say between 50 to 60%, somewhere around there. I'm ballparking at this point in time, but there's a significantly larger percentage of local applicants applying for trademark protection. And I mean, I can't give you the actual specific breakdown of the industries that they represent, but I would tell you that they represent almost all. Textiles, beverages, food, snacks, confectionery, bottles, services. We receive applications across the board then for these things. So I can't, in terms of trademark, I can't really pinpoint for you where the majority of applications are coming from. What I would say is when I do educational sessions with persons, and sometimes we would have things like IP clinics and stuff where we meet with different business owners. Actually, a couple of months ago, we did a session, a workshop, a one-day workshop with the Tobago Business Development Unit, where we went across to Tobago and we met with some entrepreneurs, and we had a whole one-day session with them where we taught them about IP, and then we had one-on-one sessions with the entrepreneurs to figure out what their business was and what type of IP right they should be applying for. And majority of them were in the food industry, the food and beverage industry. So I would say that would probably be one of the trends. A lot of
Right.
persons come from the food and beverage industry. We would also have a lot of persons doing clothing. We have a lot of persons who are involved in things like graphic design and digital arts and services and stuff like that. And of course, we have the creative economy of Trinidad and Tobago, which if there was a study by Dr. Vanus James, I believe it was in 2016, I think was his most recent one, where he said that 5.5%, somewhere around there, of GDP and of jobs and stuff that were being created was coming from the creative sector.
Right.
So you also have a lot of persons involved in the creative sector as well. And as we are approaching Carnival, you're going to find a lot more persons jumping up in the creative sector band then. Coming out with music, coming out with clothing lines or designs and stuff like that. So it's very difficult to give you a direct answer, but I'm giving you the overall atmosphere of what goes down in terms of IP in Trinidad and Tobago.
No, but you gave me the answer because based on my research, generally the trends for the IP generation will be in manufacturing, as I said, fashion, creative industries, technology, healthcare, agriculture, energy, and then, aerospace, which we'd already do too well in Trinidad. I don't know when is the last shuttle we launched. And then and then sports. You have to protect your Real Madrid branding at all times.
Your Trinbago Night Riders.
Oh, yes, I watch that too.
I'm telling you, and we might make light of it, but it's important because the other part of your question really was on where is the largest opportunity for growth. And as you mentioned that, I'm here thinking, and Nicholas was giving some examples. Well, I guess exactly that question. Where is the opportunity for growth? Because I'm seeing people coming out, for example, with carnival costumes that look very similar to other costumes that were there before. Could I protect that? Could I protect my design? I'm seeing people coming up with different clothing lines. As you said, if you look at some shorts and I'd keep it a male clothing because it's men talking here. And, I might see the same design with a different logo. So where's the opportunity and what could be done?
Well, I would say trends, again, it comes back into market analysis, determining what or riding different waves of momentum, I would say. So we go into the Christmas season. What are the most popular trends around Christmas season? But then again, you can't always depend on a trend because sometimes trends develop into something larger than itself, or sometimes a trend might just fizzle out because it's a fad. So it really depends on monitoring patterns, taking a look at the lifeline or the lifespan of certain things. So right now you've seen a noticeable trend in terms of digital innovation, right? A lot of persons getting involved in the service industry, so providing services. You also Carnival coming up, and of course you can get industrial design protection for how costumes look. But what is of course the first point is to get it protected so nobody else could copy your design. But Carnival designs or mass designs are usually locked down into the particular year that they came out. You wouldn't see anybody recreating a design for next year, right? So is it worth it at the end of the day to go ahead and protect a design? Now that is up to the designer in themselves, right? What they intend on doing with the design going forward. So you can very much stick to things like if you're talking about in the copyright industry, of course, music is something that is there forever and it will always remain there. of course, we could talk about things like graphic design and advertising and all these kinds of things, the creation of content, because a lot of persons are well, they need now persons who would come up with these kinds of things for them. And again, this comes down into, this is a nice little cross section or crossover between providing a service and also content creation. So
Yes.
heavily copyright based, which again furthers the Dr. Vaness James report in terms of copyright industries in Trinidad and Tobago. We would have a handful of persons who get involved into engineering, but again, what is the trend in engineering? What exactly would be something that would be benefit Trinidad and Tobago in terms of engineering? Yeah, you could probably come up with a device that is going to help the agricultural sector, because maybe we are planning on doubling down on our agriculture. So maybe you could take a look at the creation of devices that could make operating in the agricultural field a lot easier, a lot more productive. So if you want to take a look at the trends, take a look at things like budget allocations, take a look at what everyone is trying to focus on, and then try to determine. And this is something that we would have gone over with. We had a competition recently where we invited different entrepreneurs and stuff like that, or persons who had ideas, to take part in the competition. And the competition took them from business on idea creation into business model creation, operating and utilizing the business model canvas. And something what we taught persons in the business aspect of the competition was, what are the pain points you are trying to address? What are the pain points of persons in a particular field? And how could you address these pain points? So if you're looking for trends, take a look at different areas and take a look at, or try to determine for yourself through surveys or research, what are the pain points in those areas? Because if you address a pain point, persons would buy into your product because you are helping them out at the end of the day. And of course, if you are creating solutions that are solving the pain points, you are creating intellectual property. You're putting in your intellectual property out into the world. And if depends on what you've created, you apply for the intellectual property right that's going to protect that.
Still, customer pain.
Customers' pain. Find the best problems to solve in a business way. Solve that business pain, right?
And then get it protected.
Get it protected for sure.
Most importantly, my friends, I mean, we are on the home stretch here. So I just wanted to touch on something briefly. Using previous works to create new works. I mean, in the music industry, we hear about sampling all the time. But it's not limited to the music industry, of course. From content, since we're talking about new trends and digital trends and so on, but even physical items and goods. You tend to find people decide, all right, well, I like this thing so much and it's so popular. I'm going to take everything about it or most of it and put my own brand on it. I want us to talk about that a little bit, Nicholas.
All right. Okay, so let me use clothing for this example. All right. So someone is deciding, well, I want to sell a popular brand name jeans. Actually, let's talk about Fenty, right? Let's talk about Fenty. Fenty recently said that they opening stores in Barbados and stuff like that, right?
Correct.
Okay.
Right. So let's just say somebody wanted to sell Fenty products in Trinidad and Tobago. Now, going and buying the Fenty products and coming in Trinidad and Tobago and operating your Fenty, trying to operate a Fenty store, you are infringing. You are utilizing someone else's brand in order to do these things, you should seek the permission from the brand owner. You would need to obtain permission. Most times it's a license to be able to do that. There are some situations where you could probably buy generic clothing and you slap your own brand onto that and you sell it. It is all going to come down to the agreement between you, the seller, and the intellectual property owner. Get the permission, get the license where necessary, because if you don't do that, you could put yourself at risk for legal action. Especially when you come to things like well-known marks. Because a well-known mark will, again, and so it depends situation, but a well-known mark could have an opportunity to sue or to get goods damaged or to damage goods if you are infringing on their brand, if you're utilizing their products without their permission, all of these things. So the golden rule is to have the conversation with the IP owner, relate to them what your strategies are, relate to them what your intentions are, have a discussion. It might end up with you obtaining a license from them to be a licensed reseller or a licensed distributor of that product in Trinidad and Tobago. And if you want to, for example, take popular brands and strip off the logo and put your own logo on it, all I will say is, don't get catch. If they catch you and they figure out what you're doing, you will be in some problems. Keep the golden rule as obtain and seek the permission when necessary.
But you see it with music all the time, Stuart.
Yeah, always sampling. Always relying on the hits from the past so that your song will become a hit. Because psychologically, you're saying, another song from somewhere. So automatically you're in a groove.
And I know Nicholas would tell us that it is time bound. So we will get past that first. No problem. If it has expired and you use it, I'm guessing that, But while I guess the copyright is still in place or however it works, the expiry hasn't happened as yet. And you take a certain drum pattern or a certain melody or something. And then you see these things, and I mean, you may not be able to speak to this. You see these things go to court, and sometimes take very long to be addressed, and sometimes don't even go any way of that the owner would want.
Mm-hmm. You have to remember, sometimes it might be an interpolation as opposed to a direct sample.
Mm-hmm.
So it's very, very tricky.
Mm-hmm. And this is why we could spend a whole day talking about copyright.
It's true. With respect to sampling and using melodies and stuff like that, again, the same golden rule is going to apply. Have the conversation and get the permission when necessary, because music is something people take very seriously. Yeah? You have some songs that you might sample the song and it didn't really go where it's supposed to go. But then you have situations where a song might seem very simple and it completely blows up into this universal thing, right?
Mm-hmm.
There's no way sometimes to tell what is going to do good and what is not going to do good. So obtain the permission at all points in time to ensure that you are not going to end up in legal battles afterwards. And a sample could be, there were cases where persons got sued over 2 notes. You might think 2 notes is simple, but 2 distinguishable notes. And so again, if you know you are sampling something from another creator, get the permission. Again, you could probably go ahead and chance it and do the sample and hope that they don't catch up to you. At the end of the day, enforcement is up to the intellectual property owner. If they decide, well, this person sampling my tune is not actually doing anything to my pocket, they may decide to not do anything. But let that song take off and start a trend worldwide, and it hit their radar, well, then at that point, you're going to end up in some trouble because now you are worthwhile to go after, right? At the end of the day, it is dollars and cents. Intellectual property is dollars and cents. Is it worthwhile for me to seek legal action? Am I going to spend 50,000 US to make back 5,000 US? Some people might say, I'm going to spend the 50,000 US just to make a point. Right? For example, and I'm gonna go. This was a situation I was reading up on a couple of days ago in the video game world. Video game software apps. This also falls under copyright. There's a very popular game called Fortnite.
Yeah.
And a lot of persons try to hack Fortnite so they can enable cheats and get away with playing the game by using specific cheat codes and stuff like that, right? Selling devices that enables cheats. And Fortnite was able to successfully take some people to court and win. And they end up taking the money wasn't probably worth the fight down. But to prove the point, they take the money and they give it to some charity or something like that.
Right.
They didn't even want the money. They were just trying to prove a point at the end of the day. So some people might say, it's worth it for me to figure out if the 1.4, 1.5 million people in Trinidad and Tobago infringing on my brand, or selling counterfeit products, or selling my products under a different name. If somebody in that country sample my beat and put it in a soca song, in a chutney song, it might be they might decide to just send somebody or a couple of people and be like, hey, go monitor this country and let me see what's going on. And they might not be making the money to validate doing that exercise, but they might do it to prove a point. At the end of the day, you don't know. The golden rule, get your permission.
I mean, it's very difficult in certain situations. Because, for instance, what I understand is that food itself can't be copywritten or can't be given intellectual property rights. So, for instance, I used to have a barbecue sauce. So somebody could have bought my barbecue sauce, pour it out into a different bottle, and sell it over as their barbecue sauce. I mean, the only way I could protect it would be, as Nicholas said, is in terms of the trademarking and even possibly the design of the bottle. Those things I could protect. But in terms of actual food, it was shocking to me. I didn't know that you couldn't really copyright. Oh, not sorry, I shouldn't use the word copyright. They shouldn't trademark. You couldn't trademark food.
You could trademark names.
The name itself, yes. But
if you have
product,
names, and like you rightly said, the design of the bottle, but usually the recipes, we say keep that a trade secret. Now, if somebody decide, and from a business perspective, if somebody decide to buy your sauce and rebottle it, they had to be selling that at a higher price point to make back up the money they spend from buying your sauce.
Yeah, it's not a good business model.
It's not a good business model. So like persons had to think about all those things. Like, yeah, you might build up yourself doing that, but is it worth it at the end of the day? You know what I mean?
All right. Well, as Kendall said, we kind of wrapping up. So I generally just have like 2 more questions. We were talking about the carnival costumes earlier. Now, carnival costumes, the designs may be done here, but they normally sent far to the east for production. No, I think entrepreneurs need to understand that the way, let's say, the Western world and the way the countries far to the east operate in terms of this intellectual property protection and how they value it, it's 2 different things. So you can't just be selling things wild all over the place and expect to get that protection. Some countries, some regions don't really respect it as much. In fact, they will go to the limits of cyber attacks to steal your trade secrets, to steal your data, to steal your IP. So I think entrepreneurs should keep that in mind as well. Actually, I'll just wrap up with this one question. Geographic indicators.
Yes.
we had Mr. Akua Leith of Midco.
I find it take long.
Yeah, well, I'll save the best for last, right? And we were talking about the steel pan being
Right.
given the national indicators. You know, if you want an authentic steel pan, you have to purchase it in Trinidad. So I would like you to explain like how that process might have gone about in terms of actually gaining that recognition and some of the benefits that we'll be able to garner from that. And if there are any other things that we may be able to get some geographic indicators, you know, for.
All right. So I wasn't directly involved in this one, but I have a general understanding as to how this went down. Right. So first of all, a geographical indication, it operates. It's like a brand. Let me put it very simple. It is a terminology or a term that tells you that this product comes from a specific geographical area. And because it comes from that specific geographical area, it has a unique quality or characteristic attached to it. Right? So we see that at play in things like Scotch for whiskey. At the end of the day, Scotch is whiskey. But this is whiskey being made in Scotland. That's how they get Scotch. Champagne is sparkling white wine, but champagne is sparkling white wine coming from the Champagne region of France. Right? So the geographical indication more or less kind of tells persons that, you know, this product coming from this area is a high quality product.
It's the real deal.
Is a real deal. At least that's what it's supposed to say without actually saying it, right? So the steel pan geographical indication, or in order to get a geographical indication, it's not an easy process.
Could imagine.
Right? You have to comply with specific, well, I would say you must have, or you must meet specific criteria, standardized criteria in order to have that GI. So the GI now, I think what the GI was based on was the reputation of Trinidad and Tobago for producing quality steel pan or quality steel pan instruments. And that was what it was, one of the underlying principles behind it. So I hope that kind of addresses it. Like I said, I can't go too much in depth into that one because I myself was not directly involved in this process.
Right.
But I have the overall understanding of it.
Okay. Well, let me ask you one final. This is the final question. I promise.
Yeah.
You're not a lawyer, but I don't know if you could answer this question. For the entrepreneurs, what sort of clauses or terms do you think they should be aware of when looking at a assignment of rights or transfer? Like, for instance, terms like in perpetuity and those sort of things. Anything sticks out to your mind that the entrepreneur should definitely keep their eye out for?
Okay, so first and foremost, I would say that you should at least try and enlist the services of an intellectual property attorney, right? That is beneficial. But certain things you should look for. I wouldn't say terms, I would say criteria.
Right.
Time, what is being assigned, how long it is being assigned for, what are the uses, the intended uses of it, where it is supposed to be used. Those would be certain things that should be, you should more or less have settled. So how long the assignment is working for? Is it a one-time assignment? Is it a roving assignment? Is it that you completely given up the rights to somebody else, or are you licensing it? So you're renting it out to them? How long is it going to be done for? If it's a renting situation, of course, how much money is going to be paid? If it's a product, how are you going to calculate fees? This is going to be by cost per unit. Is it going to be cost per year in terms of the agreement? So look at cost, look at duration, look at the specific license, and of course determine whether it's supposed to be a one-time assignment or is something that is going to be continued. And of course, have an IP attorney. I mean, you don't have to, but I still think it's a good thing to have. At least someone who will be more familiar with the terminologies and who will at least have your IP interests at heart, to ensure that you have a good agreement at the end of the day.
Agreed. Brilliant, boy Kendall. Brilliant.
I mean, 1 hour, 40 minutes. We'll take that out because it probably will be less after editing. But such a great conversation tonight. Excellent conversation. And as Nicholas told us on air and even off, this is just scratching the surface. We could spend days and tons of time going through each aspect of intellectual property. And I really would like to extend gratitude and thank Nicholas so much for joining the Big Potato podcast tonight. And before you leave, Nicholas, any words you would want to leave our entrepreneurs with out there?
Yeah, actually, what I would say is I would want to actually plug the IPO's website. It is a great source of information in terms of learning about the different types of intellectual property rights. Also, if you feel the need to apply for any intellectual property rights, so you feel the need to apply for a trademark or for a patent or for an industrial design, you could actually do these things online. You don't actually have to come to the office anymore. You could handle up everything online. You could apply online. You could pay online, all of those things. Also, pay attention to our Facebook and Instagram pages. Our handle is IPO Trinbago, one word. And whenever we have a webinar or a seminar or something and it's virtual, or even if it's in person, we would usually post about it. Usually these things are free to attend once we're the ones hosting it. And it'll be a great source of information for you. And finally, for entrepreneurs who would have probably already created things and they're not quite sure which IP right is most suited to protecting what they've created, one of the things that you should do is conduct an intellectual property audit, which is where you take a look at the activities that your business is involved in and things that you've created to determine what intellectual property assets lie there. And something that is going to help you do that is on the intellectual property, on the Trinidad and Tobago intellectual property website. It's ipo.gov.tt. We have, as a resource, it's called the WIPO IP Diagnostic Tool. You could search for it in the search bar. And what this is it's like a questionnaire then. And the questionnaire would ask you specific questions. And depending on how you answer these questions, it will tell you which areas of IP you are most concerned with. And that would more or less inform your decision in terms of which IP rights to apply for, or it would inform your discussions with anyone at the IP office in terms of making an application. So that's what I would like to leave you at. And I think that should be a nice way for me to end, at least.
Yeah, fantastic. As we said, so many gems tonight. I was thoroughly informed tonight for most of the episode, actually. I was just kind of rocking back listening and taking in the information, because some of this is very, very pertinent even to what we're doing here, Stuart. And I really want to thank Nicholas because he shed a lot of light tonight. Great information. And thank you for the additional resources that you directed us to as well, because I know that those resources definitely can help entrepreneurs. You heard it from Nicholas Gayahpersad himself and from the Trinidad and Tobago intellectual property office. Protect your rights out there, folks. Protect your creations. You guys are doing fantastic work at the office, and the entrepreneurs out there are doing fantastic work as well. The creatives and everybody that is producing something and has it out there for sale. Check out the website, but most importantly, check out how you can protect your products and services, your brands, your creations, etc., etc. Stuart, anything in closing, bro?
Just pleased. Another expert, giving us all this information that I believe the audience would really value. So another guest we have to bring back.
Oh yeah. That's a cliche now.
Another one to the list.
Yeah, we definitely will have to bring Nicholas back on, and probably in a different format to speak about more specific areas and get deeper into them.
Yeah,
so Nicholas,
IP is a huge topic.
Yeah. Nicholas, thank you again, sir. And all the best to you and the team at the TTIPO.
Kendall, Stewart, thank you very much for extending the invitation, and for all of the listeners of the Big Potato Podcast, thank you so much for listening as well. And Kendall and Stewart are looking forward to seeing the trademark application for Big Potato Podcast to come through.
It's on the way.
It might come through via the famous marks, it might come through
famous marks.
I like that.
All the best to you, sir. Thanks so much.
Same to you.
And folks, that's how we wrap it up on episode number 8. It was so great.
Mm-hmm.
I'm telling you, we're kind of running late though, so we're gone. Have a good evening, morning, noon, or night, wherever you may be, and keep it locked to the Big Potato Podcast.
Entrepreneurship, it's all game. The Big Potato Podcast is yours to claim. From startups to scaling up, we cover it all. So don't mess up. Monday nights, don't miss the show with Kendall and Stuart. Your time to grow, listen up. Take notes and learn. The Big Potato Podcast, next gen's turn.